We have two matters on for this morning, and the first is In Re Tribune Media Company, numbers 14-1332 and 33, Messrs. Englert and Johnston.
Good morning.
Welcome.
May it please the Court. My name is Roy Englert. I represent the appellants, both Aurelius and the trustees, and I'd like to reserve 3 minutes for rebuttal.
That's fine, and we'll probably end up going over anyway, so no problem.
Thank you. We urge the Court both to hold that this appeal is not equitably moot and to reach the merits.
Let's start with the one that's obviously the bigger one, Aurelius. You don't challenge that the $1.5 billion should be held by us to be completely unreasonable. You say it was prohibitively expensive, I think on page 8 or so or page 15 I think it was of your opening brief. But if you don't challenge that, that must mean that it's within some range of reason and you made a business decision not to put up the bond.
Well, Your Honor, there was an attempt to appeal that to both the district court and this court. The appeal of the bond amount was dismissed for lack of jurisdiction. It is true that the decision Aurelius made was that the bond was prohibitively expensive because it would have required Aurelius to bond far more than what it stood to gain and would have required Aurelius to assume risks of factors totally outside its control. But for purposes of equitable mootness, in Continental Airlines, there was a similar fact pattern. There was a bond, there was a stay offered on condition of setting a bond. The appellants didn't post the bond. Nevertheless, that was only the start of the analysis, not the end. Likewise, in Semcrude, this court has said that even when a stay is not even sought, that still only goes to one factor of the analysis. It's still necessary under equitable mootness.
But oftentimes what happens is the court just denies the stay. And so you're behind the 8 ball. Here, the court did some analysis and concluded that, okay, if you get, in effect, I'm just doing the math, let's assume you get $369 under the plan that was proposed. And you're saying you get $2.24 billion. And the delta between those two would be about $1.9 billion. And the court says $1.5 billion. I mean, it doesn't seem, maybe it's prohibitively expensive, but it doesn't seem that it's outside of range of reason.
Not all of that $1.9 billion would go to Aurelius, first of all.
Understood.
Also that $1.9 billion is the result of total success.
And you go with $369 or $432? You would get under the plan that currently is $369 million or $432 million?
$369 million above the natural recovery.
Okay.
Yes. So it was too late to raise the amount of the bond as an issue on appeal in this appeal because the time to post the bond had passed. The decision that had to be made once the stay was conditioned on the bond was whether to post the bond or whether to try to litigate expeditiously in the district court. And the decision Aurelius made was not to post the bond and to try to get matters expedited in the district court, which, of course, didn't happen. Now, in any event, the equitable mootness does depend not only on a showing that there's been substantial consummation and failure to obtain a stay, but also a showing that will leave a plan in tatters or produce some kind of perverse outcome harming third parties not before the court.
It seemed like most people who voted on this, that a core component of the reason to vote, in fact, what was the basis, I guess, of Professor Klee's analysis and was that you have a settlement. Now, maybe the settlement obviously was for far less than you think it should have been, but people voted on that. It's tough to say that wouldn't unscramble the plan, or scramble the plan, I should say, completely if we were to grant you the type of relief you're talking about.
Well, Your Honor, the plan carved up the value of Tribune among various creditors, right, as bankruptcy plans do, of course. And if the LBO lenders have to pay more money in effect, that's just saying they would have gotten less money under the plan, and the pre-LBO note holders would have gotten more money. That doesn't have to affect the operations of Tribune. Now, if money comes from Tribune, which is among the remedies we suggest, that would affect Tribune. But Tribune has $757 million cash on hand. It's a healthy operating company at this point, and the district court didn't even consider whether a partial remedy or a combination of remedies might suffice.
But you asked for it all. You didn't present the court some sliding scale of how much money you wanted. You wanted them to vacate the plan. Yes? Isn't that the relief you wanted from the district court?
Yeah, that's correct, but the timing here is important, Judge Schwartz. The briefing in the district court was all completed before the plan was consummated. The merits briefing in the district court. The equitable mootness briefing came later, but the merits briefing in the district court was all before the plan was consummated. Precisely the same kinds of considerations that underlie the equitable mootness doctrine do suggest that had the district court ruled before December 31st, 2012, it would have been better to send the parties back and say this plan doesn't work, come up with another one.
So are you trying to say that because the district court didn't rule within this time frame within which your client was hoping, that should mean the plan should be scrambled?
No, not at all. Our position, Judge Schwartz, is that even post-consummation there are plenty of remedies available that do not scramble the plan.
Well, let's take the first one that Judge Ambrose asked you about, which was the one that Aurelius seeks. And then I'd like to talk separately about the trustees, okay?
Sure.
The one that Aurelius seeks a healthy portion of the cash on hand you just recited, correct?
If it comes from Tribune.
Where else on the Aurelius claim would the money come from?
From the LBO lenders, who are the very parties who would be defendants in a fraudulent conveyance claim.
But those claims have already been settled, and therefore you'd be asking that the settlement agreements and releases that have been signed all be undone, and that monies that those settled parties paid or received, depending on where you sit, would have to be returned to put everybody back to where they were, correct?
Except I thought that your proposal doesn't require you to pay back the money.
Well, it could be done either. It could be done in several different ways. One would be...
Sorry, Judge.
No, go ahead.
I'm happy to answer both Judge Vanaski's and Judge Schwartz's questions. We have proposed alternative remedies. One is indeed going back to square one, returning the money and litigating these claims against the LBO lenders with appropriate safeguards. We are willing to put our money where our mouths are with regard to the strength of the fraudulent conveyance claim.
But that means only your money would be returned, the monies that you received.
We would return the $369 million, yes, and we would ask that the appropriate safeguards be in place to make sure the LBO lenders' money was genuinely on the line as well. That could be worked out in the bankruptcy court. But another approach would simply be to go back to the bankruptcy court, say $369 million was too low in light of the bankruptcy court's determination that arguments that would invalidate the Step 1 transactions were in equipoise, and say there needs to be a new number, either imposed by the court or negotiated by the parties. But the result, if that remedy ultimately prevails, is a transfer of money as between different parties who took money out of Tribune as part of the bankruptcy case. It's an entirely fair way to remedy an error of law. Does it disrupt the expectations of parties to the settlement? Yes, but that's not a ground for equitable mootness all by itself. Equitable mootness is supposed to be a rarely applied doctrine that involves fatally scrambling the plan, not just fatally scrambling the settlement, but the plan itself. And what does scrambling a plan mean? Scrambling a plan means making the reorganized debtor be put in a position where it can't operate as a reorganized debtor, threatening it with bankruptcy again. The fact that different creditors relied on the settlement to try to take different amounts of money out of the estate shouldn't be a ground for equitable mootness. It is the whole point of the challenge, is that the wrong numbers were used in the plan because different creditors were awarded different pieces of the pie. That should not by itself be a ground for equitable mootness. That's not scrambling the plan, and it doesn't involve any impact, let alone an inappropriate impact on third parties not before the court.
Let's talk about, if we could, the trustee component. If you put your hat on for the trustees, and you're asking for the return of funds that, as I understand it, your client, the trustees contend, were paid to subordinated entities, correct?
I didn't hear the last part of the
That
question.
they were paid to subordinated entities.
The holders of the phones,
That's right.
the phones and the EIG notes.
Yes, that's
So
right.
if we look at those, that it's roughly $29 or $30 million, am I correct?
Yes.
Okay. If we look at that component, the monies that are involved would come from those who agreed either to take a lesser amount, an amount of money, or a lesser amount of money, but an interest in the litigation trust, correct?
Correct.
Okay. So if we focus on, there were, and this is from the district court proceedings, there were about 113 or so who took some money and said, I'm not interested in the litigation trust. There were about 600, though, who said, I'll take a smaller amount and an interest in the litigation trust. And those folks are, as I understand it, unsecured trade creditors and other unsecured creditors and retirees. They're not before the court. So if we don't order disgorgement of the money and we adopt what I understand your other alternative is, which is a adjustment to the litigation waterfall, if I understand this right?
Yes.
You're asking us to make a decision that would enable payment or change the interest held by those who aren't in front of the court. How is that equitable?
Well, first of all, I quarrel with the premise they're not in front of the court. They're appellees like any other appellees. Second,
the unsecured creditors and the retirees are appellees?
Sure.
Okay.
Sure, they were parties in the bankruptcy court, and they were represented by counsel in the bankruptcy court. They haven't chosen to participate in the appellate proceedings, but that doesn't make them any less appellees. In any event, it's equitable. Well, it's equitable for multiple reasons. Let me start by addressing the cash-only versus cash-plus litigation trust interest.
Okay.
The only difference was 2.45% in the amount of cash they got. So surely that 2.45% should not be the tail that wags the dog of whether the statutory right to appeal is honored. The doctrine of equitable mootness is not meant to say if a plan is complicated enough and has some small differences, then the appellant loses its entire rights. Beyond that, there are lots of ways to structure a remedy that gives the trustees the $30 million if they do prevail on the merits of their appeal. One is simply to ignore the 2.45 and just have it be as if there were 32.73 and give money until the $30 million is satisfied. Another, as Your Honor.
Where is that money coming from? I'm sorry.
From Class 1F, from the other parent claim.
So so you have a disgorgement. Part of your proposed remedy would be disgorgement from the other Class 1F.
Yes,
recipients.
and recall that 60% of that claim is held by an affiliate of Oaktree.
Or the litigation interest could be reassigned or some combination, et cetera.
That's correct. Any combination that results in enforcing the subordination agreement and taking $30 million away from those who shouldn't have gotten it in the first place and giving it to those who should have gotten it under the subordination agreements is an available remedy. And even if for some reason, for the $30 million, there should be a way to get it all, but even if for some reason you can't get it all and you can get some of it, this court and many other courts have held that there is not equitable mootness as long as a partial remedy can be afforded. So there's a very wide variety of ways that are entirely fair to lead to the result that should have occurred in the bankruptcy court, which is enforcement of the subordination agreement. Is there some complexity because of the number of parties in Class 1F? Is there some complexity because of the election? Yes, but that by itself shouldn't drive the equitable mootness determination.
Let me ask a question relating to a takeoff on what Judge Schwartz was asking about. Who are third parties that can justifiably rely on a plan? Now, in Judge Slobiter's majority opinion in Continental, the debtor, the reorganized entity, and investors in the new entity are particularly persons you would think about. Should it go further than that? Because to some extent, when we talk about third parties, we talk about a universe. But the question is, in that universe, are some more justified in relying on a consummated plan than others?
Yes, those who bring new money into a bankruptcy estate are those especially entitled to rely on a consummated plan. That's not this case at all.
Understood.
The LBO lenders took money out of the bankruptcy estate. The only question was how much. And there is an argument strongly pressed by the other side on this appeal that shareholders in Reorganized Tribune should be protected as innocent third parties. But of course, if a publicly traded company or any widely traded company can treat its shareholders as third parties who are the kinds of parties the equitable mootness doctrine is intended to protect, then instead of having equitable mootness doctrine be a rarely applied doctrine in an uncommon act, we're going to have equitable mootness in every case. The organization in the corporate form does mean that shareholders take the risks of the company they invest in, and it's particularly so that appropriate that be so in this case because there has been disclosure all along of the pendency of these appeals. Other courts have attached significance to those disclosures, and this court should as well. It should not treat the shareholders of Reorganized Tribune as the innocent third parties the doctrine is designed to protect.
But when you talk about investors, I assume what you're talking about are those who put in new money.
Yes. Those are the most, if there is to be an equitable mootness doctrine, those are the most appropriate investors to protect under that doctrine.
And who else are third parties that should be included if we continue with the SEM-crude way of analyzing the continental factors? That is there substantial consummation, and if so, does it fatally scramble the plan if you were to be given relief, or does it affect third parties who have justifiably relied? Who are the third parties is in effect what I'm asking.
Well, we would suggest that it be a fairly narrow universe, but there will be cases in which trade creditors should be protected. We don't think this is one of them because of the nature of the proceedings below, but there will be cases in which trade creditors are a more substantial portion of the debt and would be a more substantial portion of the remedy, and the court might wish to protect them. But mainly it's those who put new money into a plan.
And how about the reorganized debtor?
The reorganized debtor is most surely not a third party, not before the court. It is by definition the central focus of the bankruptcy case, and saying that the reorganized debtor gets to rely on a plan to defeat appellate rights because of its reliance on a plan is very problematic. No Article III judge will ever have touched this case or any other case in which the appeal is dismissed at the district court level for equitable mootness on the merits if the doctrine is said to protect a reorganized debtor and its own reliance on the plan. It becomes a self-fulfilling prophecy if the debtor says, we put forward this plan, we relied on it, and now that it's been resolved by a bankruptcy court, it's too late to resolve it after substantial consummation on appeal.
In connection with going back to when you were trying to get this resolved either in the 161 days before ultimately there was consummation of the plan, or by being offered the chance to put up a bond, what was I'm still hung up on the offer of the bond, it not being appealed. You made a business decision, your clients made a business decision, okay, we're going to try to get this expedited rather than putting up the bond, even though you've told the court there is a very, very good chance that we're going to get the full $2.24 billion that we're seeking, and we're going to be very successful in connection with this fraudulent conveyance action, this LBO action. And yet, you don't go forward. So what was the thought process here?
Well, several things. First of all, the bond ultimately sought, after a lot of back and forth in the bankruptcy court, was not a full, the stay ultimately sought was not a full stay pending appeal, but a 180-day stay. And so the entire thought was that the district court should be able to resolve the appeal within 180 days. Instead, the plan consummation occurred 161 days after the notice of appeal was filed.
Well, ultimately didn't even get resolved until 2014.
Correct. But the entire premise of the stay proceedings in the district court was to buy time for the district court to handle the appeal on an expedited basis. Ultimately, with 5.5 months passing from confirmation to consummation, the district court had those 5.5 months. Now, as to the dollar amounts, again, the $1.5 billion bond was not set on the basis of how much Aurelius or any other pre-LBO note holder might gain. It was set on the basis of what harm might occur to parties on the other side because of things like fluctuations in the stock price, things totally out of Aurelius' control. And as to the chance of prevailing, yes, Aurelius very much is willing to put its money where its mouth is and pursue litigation of these.
That begs the question, when they had that chance, they didn't put up the bond.
They didn't put up the bond. They would be happy to litigate, but the opportunity to litigate was gone on confirmation of the plan and wouldn't exist again unless and until an appellate court reversed. So it's not that there's a 100% chance of getting 100% recovery or any quantifiable chance of getting 100% recovery. To get 100% recovery, Aurelius would have had to prevail on appeal from the confirmation order and then prevail in litigating the fraudulent conveyance cause of actions. It's also true
The
that
face amount of what you purchased was what? Was it $2.24 billion, or was it something just less than that?
Aurelius is considerably less than that. That's the entire amount for all pre-LBO note holders.
Okay.
I don't have an exact Aurelius number,
Okay.
but Aurelius' portion of that.
So in effect,
they're quite considerable.
The way it works out, obviously, they're paying somebody, the pre-LBO note holders, some cents on the dollar, and obviously that does not have to be disclosed. They make a business decision. We've paid this. We think if we have control of this litigation, we'll get significantly more. You didn't have control ultimately because they went with the DCL plan, and you were pretty much by your lonesome, and whether you made money or didn't, I don't know. But the point is, those are all business decisions you make. And the bankruptcy judge here, unlike a lot of bankruptcy judges, really took into account, okay, what would be a reasonable amount to ask you to put up in order to allow you to go forward and to have full litigation or a chance for litigation if it comes back to us on the merits.
But again, that was set based on the harm to the other side, not based on the potential gain to Aurelius' side. And with regard to the potential gain to Aurelius' side, Aurelius and the other pre-LBO note holders, yes, we love our chances of prevailing if these matters are ultimately litigated, which would require a reversal on equitable mootness and a reversal and a reinstatement. Right. But it's also true that these causes of action could be settled on remand, and we have argued on appeal that our chances of prevailing for a full recovery are north of 50%. But that merits argument on appeal is largely based on the bankruptcy court's determination that the theories for invalidating step one were in equipoise. And there are also equitable arguments for putting the LBO note holders in line behind the LBO lenders in line behind the pre-LBO note holders, and those we think should have had more weight than the bankruptcy court gave them. But the biggest argument is that the chance of invalidating step one was about 50%. Based on the determinations, first of the examiner and then of the bankruptcy court, of the chances of prevailing on that issue, Aurelius' willingness to put its money where its mouth is wouldn't extend to saying we think we have a 90% chance of prevailing. Aurelius is certainly willing to litigate, but a fair business decision would take into account, not necessarily agree with, but take into account the examiners and the bankruptcy court's conclusions about the likelihood of prevailing and invalidating the step one transactions.
When you asked for expedition in the district court, was there any type of hearing on your motion, or was it just done on the papers?
I do not believe the district court held a hearing. I'm not 100% sure of myself on that, but I'm fairly confident it was done on the papers. And then the briefing was completed by October, mid-October, and the plan was not consummated until the end of December. Okay,
and did the court give a reason, or just an out-and-out denial?
Just an out-and-out denial.
Okay, I mean, it is extremely busy with patents. I mean, it's probably one of the, maybe the busiest district court in the country, but I just didn't know if a reason was given or not.
Courts are busy, and of course that's a fact of life, but it's also true that there is a statutory right to appeal, and that there shouldn't be a 1-2 punch in which a court is too busy to give expedition, and then the court says it's too late. That's the basic thrust of our position. It's not meant as a criticism of the district court.
But was there a separate request for a stay of implementation of the plan by the trustees?
No.
in the trustee's claim? There wasn't a
Oh, no,
separate...
the trustee's claim? I'm sorry. I didn't know.
Yeah, the
I apologize.
trustee's claim.
No, Aurelius.
Is there...
Well, I take that back. I believe the trustees requested a stay. I believe they didn't
Okay.
offer a possible bond amount.
They were not given the bond option with respect to... Because their claim is different. And
Correct.
that was leading to my question. Is there a basis for distinguishing in the application of this equitable mootness doctrine because of the difference in the nature and magnitude of the Aurelius claim and the trustee's claim coming to different results, one equitably moot and one not equitably moot?
Well, we'll take what we can get, but let me suggest a couple of things in response to that question, Judge Vanaski. Number one, even if the law is that the less that's at stake on appeal, the more likely the right to appeal is to prevail over the equitable mootness doctrine, partial remedies still have to be considered. And the fact that Aurelius seeks a very large amount of money compared to the trustees shouldn't mean that Aurelius is not entitled to pursue any theories for any amount of money. We respectfully suggest that that is not a proper outcome. Second, there is something illogical about saying the more you were harmed by the bankruptcy court's errors, the less your right to appellate review by an Article III court. And it is a strange aspect of the way the case law has developed on equitable mootness. Let me...
But you could flip that around by saying, by not posting a bond, it makes equitable mootness more likely. Had you posted a bond, it makes equitable mootness significantly less likely.
Yes, but $1.5 billion really was too high a price to pay for...
Yeah, and it's to me, it's a business decision. They made a business call, and it's not for you or I to tell them that they're right or wrong.
Well, again, I'll just fall back on the fact that both in Continental and in Semcrude, there was a suggestion that that is the beginning and not the end of the equitable mootness analysis. And in Continental, it really was the exact same facts. The opportunity to post a bond was offered, the bond was not posted, and still there was a 7-6 split on whether the equitable mootness doctrine applied in that case.
If I could just follow up on Judge Vanaski's question, because I'm not sure I heard your answer. The issue on the bond, are you saying that a bond was only offered, you got to stay for Aurelius's claims only if you posted a bond, but as it related to the trustee's claim, there was a denial?
No.
Okay.
And I'm not 100% sure of my recollection on this. The record is clear, but my recollection is a little less clear. But to the best of my knowledge, what happened was that a stay of plan consummation, that is an entire
In its
stay,
entirety, okay.
was offered
Thank you.
if Aurelius would post a bond.
Thanks.
Now, I know I'm well out of time, and we haven't discussed the merits at all. And, of course, the other side hasn't briefed the merits, so we do understand that the court would want to do, if it's going to reach the merits, would want to do perhaps something more than just look at the briefs that have been filed in this court. But I do want to say there are reasons why it matters to get to the merits expeditiously. The merits will come back to this court, assuming we get past equitable mootness. The merits will come back to this court if they're resolved by a lower court on remand, no matter what. And the litigation trust currently hasn't recovered anything and currently hasn't distributed anything. But that litigation is proceeding. And by the time a case worked its way
What are the potential assets, or what's the potential recovery in that litigation?
It's very large. It's fraudulent conveyance attacks on the same transactions that were at issue in the bankruptcy court involving the LBO lenders, but it's fraudulent conveyance actions against the shareholders and not just against, and not at all against the LBO lenders. There are complications in shareholder actions that don't exist in the actions against LBO lenders, but the basic theory, which turns on the capitalization of the transferor and on the receipt of reasonably equivalent value by the transferor, the basic theories are the same. And there is a chance to recover several $1 billion through the litigation trust.
Would Aurelius have been part of that litigation trust? Would you have been in the waterfall?
It is in the waterfall.
It is in the waterfall.
So if that's the case, then you still stand to recover, yes?
Something.
Stand to recover something, yes.
But I think you just characterized it as the likelihood, unless I misheard, the likelihood of recovery is dollar-wise could be quite great. So you're not without relief is, I guess, my point.
Could be quite great. Well, obviously we're not without relief. We got $369 million above our natural recovery and litigation trust interest. But the argument is not that we didn't get any relief. The argument is that we didn't get enough relief because of the very strength of the claims against the LBO lenders. And the idea that the LBO lenders should be able to walk away recovering lots of money from the Tribune estate that really should have gone to the pre-LBO note holders on a properly valued settlement because there might be recovery against the shareholders is a strange way of looking at equity. It was the LBO lenders who were more responsible for the conveyances that are attacked as fraudulent, both in the litigation that was purported to be settled by the DCL plan and in the litigation by the litigation trust. The shareholders, well, there's a variety of equities with regard to the shareholders, but they were not uniformly as centrally involved in these transactions as the LBO lenders.
But the one thing I don't hear in your brief arguing is that there should never be equitable mootness.
Well,
to some extent, it seems like you're dancing around it, but I don't see that argument being made in the briefs at all.
Let me say flat out, there should not be a doctrine of equitable mootness. It is constitutionally
every circuit
suspect.
has it, as you know.
Every circuit has it, as I know, and the reason I don't say more.
Except in the Federal Circuit.
Yes, Your Honor. The reason I don't say more before this three-judge panel is obviously it's bound by the en banc decision in Continental Airlines to honor a doctrine of equitable mootness. But is it our position that there should be no such doctrine? Yes. Is it our position that Judge Alito's dissent was correct? Yes. Is it our position that the matters dealt with by equitable mootness should never lead to a threshold dismissal, but should instead be taken into account in fashioning remedies after a claim is adjudicated on the merits? Yes, that is our position.
At the same time, there are cases that one can easily conceive of where there are, if you go back, you have literally created chaos with regard to a relook at a plan that's been substantially consummated.
And our respectful suggestion, if Continental were to be revisited, is that those cases can be dealt with in fashioning remedies, just as then Judge Alito said in his Continental dissent.
That was his general statement. One can conceive of cases where it would be completely chaotic and be very, very difficult to do in certain cases if you have to do a do-over. For example, let's go back to Continental. If you had to do a do-over in Continental, the question there was, would it really fatally unscramble the plan? That was the issue, and one could make a darn good argument, I think, there. It would not have. But there's a lot of cases where it would unscramble a plan, and you would be back to square one all over again. And that seems to be against the principle of a fresh start, where you've started, you've finished, then you have to go back to home plate, probably back to the dugout to figure out what you want to do once you get to home plate. And so that seems to be why, every circuit, and remember in Continental, we were essentially following what the Seventh Circuit did in an opinion written by Judge Easterbrook. I don't know of anyone that's, other than the dissent in Continental, that really has made this strong argument that you shouldn't have it at all.
Well, with respect, the extreme cases can be dealt with by extreme limitations on remedies, but the current doctrine, instead of limiting remedies after there's been an adjudication on the merits, says that no Article III judge should ever touch some number of these cases. And if arguments such as those being presented on the other side in this case prevail, that will not be a small subset of cases as it's supposed to be. It will be a very large number of cases in which there is no Article III review. That is not the scheme that Congress designed. That is not the scheme the Constitution designed, frankly, to have appellate rights cut off wholesale, not retail, but wholesale, in cases in which courts are concerned about whether remedies would or would not work down the line if the appellant prevails.
All right. Thank you very much.
Thank you.
We hear from Mr. Johnston.
May it please the Court, Jim Johnston on behalf of the Tribune appellees. Your Honor, this is one of those rare cases where chaos, literal chaos, would ensue in the event that the appellants achieve the relief they sought.
I mean, there's one argument that Mr. Englert made in his brief that you had a window here. I guess they were waiting for some administrative approvals. And the window was, at least initially, 161 days. And he made the point that it's like everyone waiting for the candle to burn out. And then once it does, we say, well, can't do anything about it. In here, something could have been done.
And Tribune actually attempted to facilitate that process. We stipulated to a briefing schedule.
And the briefing was completed by what, October 11th of 2012, right?
Yes, several months before the actual effectiveness.
And before the court, did you oppose the expedition of the briefing?
We did not oppose expedition. What we did oppose was the Aurelius request that its appeal be heard separately from the other 5 pending appeals of confirmation at the time. Mm-hmm. We thought there were 6 different appeals of confirmation. They all should be heard and adjudicated together. The record should be designated together, that they should go to the same judge. It made no sense whatsoever to us to have them heard piecemeal. So we didn't want Aurelius to get out in front of the others, and Judge Sleet agreed with that. He consolidated the appeals, and ultimately the cases proceeded up together. I think it's important to note on that one point with respect to the interim period. We heard Mr. Englert say that their stay request morphed from an unlimited stay to a 180-day stay. The fact is that had a stay been granted, Tribune would not have been able to take any of the steps necessary to progress to exit the case. The reason why there was a substantial delay between plan confirmation and effectiveness was that confirmation was contingent on approvals by the FCC. And the FCC, in many cases, has stated, we're not even going to look at the file until we know that there's a confirmation order that's been entered, and that once we do the work that we have to do, the debtor can emerge. That was our case here. Because there was no stay, the FCC went to work. We got our waivers, and then we came out of bankruptcy. I think it's important to look at what this case was. The Tribune bankruptcy case was about how to divide a $7 billion pie among $12.7 billion in claims, how to carve up the value, as Mr. Englert described it. The appellants clearly didn't like the way that the Tribune plan divided the pie. They thought that other creditors got slices that should have gone to them. Aurelius thought the plan settled Tribune's claims against senior lenders too cheaply, so that the lenders got a bigger slice of the pie than they deserved. And the trustees argued that the plan incorrectly enforced the subordination agreement.
What is the amount that's being requested in the litigation that continues with regard to the LBO?
There are several theories of damages. The biggest component is a lawsuit against shareholders for intentional fraudulent conveyance for every dollar that was received in the LBO. So it's multi-billion dollars.
What's the status of that litigation right now?
Let me touch on the other component because they're different. The other component is a case by the litigation trust against directors, officers, professionals of Tribune for having participated in the LBO. Those claims are currently stayed. Nothing's happening on them. They're all before an MDL panel in New York. The claims against the shareholders are subject to a motion to dismiss that has been pending before the district court for quite some time. There's some speculation that the district court is reserving judgment until a related appeal that's before the Second Circuit on individual creditor lawsuits against shareholders is determined. Today we're here talking about carving up the pie to address what would happen if, hypothetically, an appellate court were to conclude that the bankruptcy court got it wrong. And the real issue is, could the Tribune pie be redistributed fairly, equitably, and feasibly? Based on what really was undisputed evidence before him, Judge Sleet concluded not. he found that there was no equitable remedy available, and he dismissed the appeals as equitably moot.
Let's go back to the bankruptcy court in terms of the plan that was proposed. Aurelius proposed a plan, and the debtors, the lenders, and the creditors committee proposed a settlement. And you had Professor Klee coming in and suggesting that what was proposed, I guess the $432 million settlement, was as good as you could get, but for success under the LBO action. And how did the court, what was the analysis as to whether there might be success? Because it sounds like what the bankruptcy judge was saying is in equipoise, that means it's 50-50.
The chronology was actually reversed. The examiner's report came first.
Okay.
The LBO claims, the committee was investigating them. There were a huge focus of the case, and finally Judge Carey said, we need an independent analysis of this. So Professor Klee came in, delivered his 1,200-page report, and frankly it offered something for everybody. It put all constituents at risk, and by that I mean the lenders who were subject to the avoidance claims and the pre-LBO creditors, as they call themselves, who would benefit from the avoidance claims. The lenders seized on the fact, as you noted, Judge Ambrose, that Professor Klee found basically 5 of the 6 realistic scenarios in litigation would give the lenders substantially great recoveries. The note holders and other unsecured creditors seized on the fact that the examiner had found plausible claims for avoidance. He didn't dismiss them out of hand. So with that backdrop, the estate fiduciaries and all parties went to mediation, and the DCL settlement and the Tribune plan arose out of that.
I thought what Professor Klee found at step 1 was that it was reasonably likely to find actual fraud, and at the second step, it was highly likely to find constructive fraud at step 2.
That's not accurate, Your Honor. What he found was a finding of intentional fraud at step 2 was potential. I'm not sure of the phrase reasonably likely, somewhere in that category.
What I had was reasonably likely to find actual fraud and highly likely to find constructive fraud.
Okay. At step 1, he did not make those findings. Step 1, he did not find a likelihood of prevailing on the merits of either actual or intentional fraud. And that was significant because of the reduction in Tribune value. Even preservation of the step 1 debt would have delivered the lion's share of the lender's recoveries, standing by itself. With respect to the bankruptcy court's equipoise finding that we saw so much about in the Aurelius brief, that was not a determination, as Mr. Engler put it, that there was a 50-50 chance that the avoidance claims would prevail.
It meant what Judge Carey was just unsure as to what the outcome would be, or what?
A couple of things. Yes. First and foremost, it meant Judge Carey thought the issue was open. His opinion states that there was no evidence that, quote, a court would decide this issue one way or another, unquote. It's also important to note that even a 50-50 finding on the particular issue he was talking about, which was capital adequacy of Tribune at step 1, would not have equated to a 50-50 chance of success on the avoidance claims. The bankruptcy court didn't address capital adequacy of Tribune's subsidiaries, which was where the lion's share of value resided, but much less debt. So there was clearly a much less possibility of capital inadequacy at the subsidiaries. And the bankruptcy court also didn't address a whole panoply of defenses asserted by the senior lenders, including good faith defenses under Section 546E of the Bankruptcy Code and the like. So to take the one line in the bankruptcy court opinion and extrapolate that into a 50-50 chance of success on the merits of the claims is a bridge too far. I think it's also worth noting that implicit in the Aurelius argument is that, boy, Judge Carey, you found a 50-50 chance of success on these claims, but then he signed off on a settlement that provided for a much lower payment. He must not have known what he was doing. Respectfully, Judge Carey is a very experienced judge. He knows the law. He knows the bankruptcy code.
His reputation precedes him. There's no doubt.
And had Aurelius truly believed that that's what Judge Carey found, it would have sought reconsideration of the ruling. It sought reconsideration of another part of the confirmation ruling, but was completely silent on that point. I think that speaks volumes. And I think it goes, Judge Ambrose, to your larger point that Aurelius didn't do everything it could do here to prevent the harm that Judge Sleet has now found would have occurred.
Did you proposed, I assume, or the debtors proposed a bond. What was the number that they were seeking?
We offered essentially 2 or 3 theories of recovery. The largest bond amount was premised on some harm to the debtors and transactions that was up to $4 billion or so. Judge Carey, after a full-day evidentiary hearing where he took testimony, there was cross-examination, and then he wrote a pretty lengthy opinion on the bond, concluded that $1.5 billion would be sufficient under the circumstances. I think he noted that it was conservative in terms of much lower than the amount requested by the debtors. So that's how he landed on the $1.5 billion figure. Notably, the appellants didn't offer anything. They didn't offer $100 million, $750 million. It was, no, we're not going to offer anything. We don't think we have to offer a bond. For the trustees, that's very significant. If the trustees had offered a $30 million bond for their specific issue, that amount could have been reserved and there would be no equitable mootness with respect to that appeal. But they didn't. They sat on their hands.
Although, maybe we segue briefly to that, $30 million out of $7.5 billion is what, 40 basis points, 0.4%?
No question. It is a very small number in the overall scheme of things.
And I mean, the remedy is pretty, the opening brief, I think on page 8, lists about 4 or 5 remedies. If you include the combination, you could disgorge, you could have the litigation trust rearranged, among other things, and you could have some combination, and there were at least 2 others. I mean, a host of ways you could deal with that small amount.
Well, I think it's useful to conceive of them in 2 ways. Either Tribune pays another 30, or you get the $30 million back from the creditors who the trustees say were overpaid.
Yeah, a disgorgement in effect.
Right. With respect to Tribune, the remedy for overpayment of one creditor for misenforcement of the subordination agreement isn't to make the debtor obligor pay twice, which is what they suggest when they say Tribune should just pay it, and $30 million isn't a very large number in the scheme of things in this case.
Well, I think, you would send it back to the bankruptcy court and let the bankruptcy court figure it out. I mean, either Tribune pays, you have disgorgement, you have the litigation trust rearranged, you have some combination, etc. Those all sound like they're plausible ways, and those are arguments that can be made to the bankruptcy court, not necessarily to us, but it certainly seems like there is a remedy. And yes, the plan is substantially consummated, but it's pretty darn clear that this amount is not going to fatally scramble the plan if they get relief. So then it comes down to, well, are there third parties who justifiably rely? And if the subordination agreements are as they say, and they should prevail on that, then there's no justifiably involved. So it's a tough argument for you to make.
I would take a different tack at it. In terms of justifiable reliance, what we're talking about is the 715 other parent creditors. That's 517 trade creditors and 191 retirees, plus the swap claimant. Those creditors were not parties to the subordination agreement at issue. The subordination agreement at issue was the phones indenture. So I would venture to guess that not a single one of them had ever read the phones indenture, knew what it meant. They were simply trade creditors or former employees of the debtors who had claims against the debtors and received checks in the mail, and checks and or equity and or litigation trust interest. It's certainly understandable, I would submit justifiable, that those creditors proceeded to rely on the fact that a bankruptcy plan had been confirmed and they got their money out of it. I'd also note that in Continental, one of the principal policy bases for the equitable mootness doctrine is to encourage reliance on unstayed confirmation orders. And there's a discourse in the opinion there that actually says, we're not going to get into the business of deciding whether reliance was reasonable or not reasonable. We think as a policy matter, it makes sense for people to go forth.
But are you saying that there's no partial relief that can be given if this is found not to be equitably moot with regard to the trustees?
Yes, for two reasons. With respect to Tribune, there's no authority, no precedent for requiring a debtor to pay the same debt twice, which is what we would submit happen if Tribune.
Okay, let's go to disgorgement or going. It almost seems to me, just to analogize for a moment, you see this come up oftentimes in the tax context, where you'll have a state tax and somebody will appeal it to the Supreme Court, and the Supreme Court will, let's say, rule in favor of one or the other, and they won't get into the remedy part. They'll send it back to the state, and they can either take it from those who pay too much or take it from those who got a windfall, or perhaps going forward, say those who got paid too much, they will get less going forward. It sounds like, quite simply, what you could do here.
I don't think so, Your Honor, because, one, we have a very large number of creditors, as I mentioned. We have a plan that provided, as Judge Schwartz noted, those creditors with a panoply of treatment options, including equity, including litigation trust interest, including all cash. You have the difficulty of not only looking at those 715 creditors, but then the reverberations across the capital structure beyond that. Because
for $30 million, I think the reverberations would be fairly small.
Well, what I mean by that is the swap claim is in this class, but the swap claim is unique because it, too, was guaranteed by all of Tribune's subsidiaries. To the extent that the swap claim's distribution in this class was reduced, then its claim on the subsidiaries is increased. The increase in that claim on the subsidiaries results in a decrease of all the payments that were made to the senior lenders. So it goes beyond just the 715 creditors in this particular class. And
so Class 1F is what, 715 you say?
Correct.
And most of them are comprised of
my numbers show 517 trade, 191 retirees.
Okay. And you say disgorgement, I mean, it's unwieldy, but it can't be done?
It's the exact chaos that the cases speak about. If this were thrown back in the lap of the bankruptcy court would be tasked with tracking down these individuals, hundreds of individuals, finding and ordering them to pay back a portion of what they got, which included stock, which very well may have been traded now many times over, and then sorting it out.
Well, a number of those, 15% or so took, 16% took a lump sum, did they not?
That is correct. I think it's 16% took all cash. In terms of number, that's looks like about 112 took all cash. Just for reference, the document I'm referring to is at the Appendix 4079, which was attached to our one of the declarations we submitted to the district court.
And if these retirees and trade creditors had to be tracked down and then they were ordered to turn over their money or divest themselves of litigation trust, they then still have claims, presumably, right? They'd have to be satisfied by the debtor, correct?
That's correct. They still have claims, and the distribution on those claims would ultimately rise or fall depending on the litigation that would continue to proceed. It would be completely unwieldy. is the
So from
point.
your point of view, it's not just simply the percentage of what $30 million represents to the overall financial picture of the current Tribune, but the consequence, as you just described, on the claims of these individuals, these retirees, and I guess you agree with your adversary, they would be, quote, parties before the court?
I disagree with the suggestion that they are appellees or parties to this appeal. Just because they're creditors in a bankruptcy case does not automatically make them parties before the court on appeal, particularly these trade creditors. I don't think any one of them appeared before the court and had counsel.
They filed a proof of claim, did they not?
Some were probably scheduled and didn't file a proof of claim.
Right. But they're included one way or another as a creditor.
Oh, yes. Yes, that's why they got their distributions.
But from your point of view, it's not just the fact that it represents percentage-wise a relatively smaller amount of dollars. You're talking about the other consequences. I think you were describing what would happen about how certain claims would rise and fall and affects the subsidiaries and things like that. Is that correct?
Very much so. I think the notion that $30 million is a small percentage of the overall estate on the disgorgement issue is something of a red herring, because it's the practicalities of achieving disgorgement. And by the way, since we're talking about retirees and individual trade creditors, it's a material amount of money to them, no question.
Now, you had mentioned, if I may, Judge,
Sure.
you had mentioned as having some significance the fact that the trustees had not offered to post a bond or posted any bond on their $30 million claim. How would this, I guess I'm looking at it from going back in time, had that been offered and posted, how would that have held up consummation of the plan in its entirety, or would this have been just carved out?
It would have been carved out. I think that's why the bond amount could have been so much lower. If the amount at issue for the trustee issues was $30 million, they didn't need to seek a stay of consummation of the plan. They simply could have set aside $30 million to be dealt with after the merits were ruled upon. They chose not to do that.
Thank you.
I did want to address one issue that was suggested in the briefing and then again today, which is that Aurelius would be happy to give back its money. That as a quid pro quo for a determination on a reversal and a determination on the merits. That's something that cannot be accomplished. First and foremost, it's important to remember that these are not Aurelius's causes of action that it wants to pursue. The claims belong to the bankruptcy estate for the benefit of all Tribune stakeholders. The individual creditors had no right to bring them themselves, and it's worth noting that Aurelius doesn't speak for all creditors or even a majority. Judge Ambrose, as you noted, the vast majority of creditors voted to approve the plan, and Aurelius didn't even speak for all of the senior note holders, which is what the trustees represent. 70% of them voted in favor of the plan. More importantly, in the settlement that is the cornerstone of the plan, the senior lenders paid hundreds of millions of dollars, we value it at $760 million, to be freed of estate litigation once and for all. If they were subjected to suit, even partial suit, I don't know how that would work by virtue of Aurelius alone giving back its consideration, they'd be deprived of their bargain. The only remedy that does away with a settlement is rescission, and rescission requires recoupment of the settlement consideration that was paid to all the other creditors.
All right. Thank you very much.
Thank you.
Taking that last point first.
We're probably going to keep you close to your 3 minutes.
Okay, taking that last point first. Depriving the lenders of the benefit of their bargain is the whole point of Aurelius's appeal. To say that that is itself a ground for equitable moves expands the doctrine tremendously. With regard to the 715 other parent creditors, 97% by dollar value is either the swap claim or the former employees. And so if the 3% of trade creditors end up being uncollectible against, so to speak, that's not a big deal. There can be reinstatement. Mr. Johnston said the examiner's findings about Step 1 were significant, and then a few sentences later he said Judge Carey's determination about Step 1 being an equipoise was merely one line that we carry a bridge too far. With respect, Judge Carey, in determining that the Step 1 claims were an equipoise after heavy litigation over those claims, was not just a single throwaway line. It was a cornerstone of his opinion. And did he not know what he was doing? That's not the phrase we would choose. Did he commit legally reversible error? Did this very good judge, under pressure to resolve this case, commit legally reversible error when he failed to follow through on the implications of his own determination that the Step 1 determinations were an equipoise? Yes, he committed legally reversible error. Did that determination apply to the parent and the subs? Yes, contrary to what Mr. Johnston has told you. The expert testimony on capital adequacy was about Tribune on a consolidated basis. With regard to the litigation trust, interests are not transferable. And right now, with no money having been recovered and none having been distributed, litigation trust interests are just ledger entries. There is no logistical nightmare. There is no chaos in reallocating interests in the litigation trust. That simply requires changing the waterfall. And my last point, after the first $110 million, the LBO lenders themselves get 35% of money recovered by the litigation trust. That makes no sense. The litigation trust is pursuing theories that, if successful, suggest that the LBO lenders would have lost the fraudulent conveyance litigation. And to award the LBO lenders 35% of the recoveries from fraudulent conveyance litigation against shareholders ends up, in effect, compensating the LBO lenders for having succeeded in settling the fraudulent conveyance claims against the LBO lenders at too low a price. That should not be allowed to stand. Thank you.
Thank you. Thank you to all counsel for very well briefed arguments. Mr. Johnson and Mr. Engler for extremely well presented oral arguments. I would ask if you would get together with the clerk's office afterwards, have a transcript prepared of this oral argument, and split the cost. Again, privilege having all of you here.